Well, good evening, everyone. I'm Alex Lanikoff, the Dean here, and pleased to welcome you all to the 6th Annual Lifetime Service Award that our Georgetown Federalist Society has awarded this year to Judge Kenneth Starr. Ken, as I look over your resume, it's really quite a story of Supreme Court advocate extraordinaire, judge, solicitor general, independent counsel, the list goes on. And I realize we could call you many things. We could put an Esquire after your name. We could call you Judge Starr. We could call you General Starr. But, of course, best of all now, we can call you Dean Starr. Your service has not been without controversy, but my guess is that you would think that a life without controversy is a life of complacency, and that is never how you would describe your life or others would describe it. In the positions that you have held, you have shown the many ways that lawyers can contribute to our society in the private sector, but most of all in the public sector. It's a wonderful model to our students. We're delighted to have you here, delighted to welcome you, and to thank the Federalist Society for hosting this event today. Thank you.
Good evening. My name is David Shaw, and I am the president of the Georgetown Federalist Society, and we are very glad to have you all here, and of course, very glad to have Judge Starr here. The purpose of the Federalist Society is to bring conservative and libertarian voices into the law school campus debate and dialogue, and we like to honor here at Georgetown some of the preeminent people who have advanced the cause of the Federalist Society. Certainly, Judge Starr is one of them. I'd like to introduce now our faculty advisor, Professor Nicholas Rosencrantz, who is a graduate of both Yale undergrad and Yale Law School. He typically publishes in the Harvard Law Review, although occasionally he is published in Stanford. He also is a dedicated teacher. Recently, he managed to show up at my 9 a.m. federal courts class, having just taken a red eye from California. So, Professor Rosencrantz.
Hello and welcome. It is a pleasure and an honor to introduce the winner of the Georgetown Federal Society Chapter's annual Lifetime Service Award to Kenneth W. Starr. I met Judge Starr almost 12 years ago. You may not remember this. I was a student in Akil Amar's constitutional law class at Yale. And Akil invited Judge Starr up to speak about constitutional law. And I still remember that day. I was struck, of course, by his effortless eloquence, which was legendary even then from his time as Solicitor General and so forth. But even more than that, I remember being struck by his graciousness, by his courtliness, by the respect that he accorded student questions. It seemed to me that he was treating student questions the way that he treats questions from the justices, as though they deserve the most careful and precise and respectful answer that he can give. By the end of that class, I was convinced that I wanted to work with him. But there was one problem. It was the fall of 1997. I was a hotshot 2L at Yale, and I wanted to go where the action was. I wanted to find a place where law and politics were intersecting and sparks were flying. And as far as I could tell, Judge Starr was engaged in the most boring work imaginable. He was investigating some sort of arcane land deal in Arkansas, and I faced a dilemma. I didn't know whether to go to work for this great man, but or go to find myself an exciting place to work, or go to work for this great man and resign myself to a summer of tedious Arkansas arcana. But after much agonizing, I decided to work for Judge Starr that summer, and it turned out not to be so boring after all. Judge Starr's been a great friend to me ever since that fateful summer. It's my honor to introduce him today. Dean Starr holds a BA from GW University, an MA from Brown, a JD from Duke Law School. He clerked for the Honorable David Dyer in the U.S. Court of Appeals for the Fifth Circuit and for Chief Justice Warren Burger. He spent time in private practice as a partner at Kirkland & Ellis, as well as Gibson, Dunn & Crutcher. He's held an amazing array of government positions, including counselor to Attorney General William French Smith, judge on the U.S. Court of Appeals for the D.C. Circuit, Solicitor General of the United States, and independent counsel during that unpleasantness in 1998. He's also an accomplished scholar and academic, currently the Duane and Kelly Roberts Dean and Professor of Law at Pepperdine. Dean Starr is also one of the most astute court watchers in the country. He's argued more than 25 cases before the Supreme Court, and he's also written a best-selling book about it entitled First Among Equals. So we're in for a particular treat this evening, as his topic is 35 years of court watching. It's my great honor to introduce the winner of the Federalist Society's Lifetime Service Award, my friend and mentor, Kenneth W. Starr.
It says address. You should get very nervous, but I want this to be interactive. And so can you hear me in the back? Not that it's relevant, but Mr. President, thank you. And I was not President Obama, but President of the Federal Bar Association. It's very good to be here. So, yeah. Okay. Oh, they're recording. So much for the David Letterman or whatever walkthrough. So, very good. Thank you, Dean. Dean, thank you. I apologize for a little bit of mix-up. I was here on time, but in any event, did they open the bar? In good Federalist Society. It's a great opportunity to get together and try some California wines. Nick, thank you for that. Dear friends on the faculty, and Susan and I even clerked at the same time. Once upon a time, we won't say what year that was, but it actually has been 39 years, so I'm glad you took 35 rather than 39 years of court watching. And I do want to reflect on that just for a few minutes and then open it up. That's much more fun and much more in the spirit of the Federalist Society. Let's get the debate going. May it be robust, uninhibited, open-ended, in the words of Justice Brennan in New York Times versus Sullivan. And you know the next sentence, which is sometimes underreported, which is the debate frequently makes us uncomfortable, but not at the Federalist Society. Right, Judge? You know, debate makes us very comfortable. So it's a great privilege to be here, and thank you for the honor, which I am happy to accept before you revoke. So it's a pleasure to be here. In fact, I was in this very room a few years back when the honor, I think, initially was bestowed on one of my mentors, Dick Thornburgh, who served as governor of the Commonwealth of Pennsylvania, Attorney General of the United States, head of the criminal division. He was a great role model, continues to be for me. He didn't think I should go in the Supreme Court of the United States, but let bygones be bygones. Let's just move on, and it shows his terrific judgment. But it was great to be here when, Libby, you and your colleagues at that time presented that richly deserved award to Governor Dick Thornburgh, a great public servant. That is one of the takeaways, even though I'm not going to be talking about public service specifically, but it is one of the takeaways that I would like for you to be left with, which is the really redemptive quality of public service. Regardless of your worldview, what turns your light bulb on in terms of worldview, conflicts of vision and philosophy and so forth, this is a great institution for training you in the value and virtue of public service. You will have that call, much more likely than not. It may be back in your hometown, as Louis Brandeis famously advised law clerks, go back to your hometown and make a real difference. But it may be right here in the nation's capital, it may be in the judiciary, serving as a law clerk, and maybe serving as a judge. But whatever it is, I would say always be open to that, one of the finest traditions of our profession, which is at its best, we're always open as members of the profession to public service. Just a few reflections on 39 years of court watching. I guess not all of those, of course, with a law degree, so less qualified, but as a student of the Supreme Court of the United States, both in a practitioner capacity, but also trying to understand in a more academic capacity what is going on. And what I really want to put before you is this proposition. And Susan, I think you will I want to call on you first, perhaps. No, never call on a professor. They'll find a way to get back at you. But I dare not call on a judge. That's the one unpardonable act. You can't call on a judge. As Judge Mikva said, Alex, wonderfully in one oral argument, that when I was the junior judge, counsel here, we ask the questions, you answer the questions, as opposed to posing questions to the bench. I believe in no small measure that the work of the last 3+ decades of the Supreme Court of the United States in the arena of constitutional law has really been an enduring reflection and meditation on the work of the Warren Court. That's my proposition. So when we scroll back, prior to the time that I was really paying attention to the court closely, as a law student, then with a law degree, clerking, etc., and I began my study in 1970 as a law student, so that was a very, very long time ago. And that, of course, was the very earliest years, literally the earliest years, of the Burger Court, which succeeded the Warren Court. In that prior decade, there had been just a remarkable outpouring of far-reaching opinions, and you've been studying those in law school. That Alex Bickel of the Yale Law School captured, I thought, very powerfully in one of his books, The Supreme Court and the Idea of Progress, that the Warren Court really seemed animated by a really unifying, not all 9 justices, but that a majority of the justices were really animated by this vision of a progressive society and for the judiciary using its Marbury versus Madison Federalist 78 type powers to bring about greater progress. This came home to me and looking at the New York Times on Saturday when on page 1, perhaps some of you saw it, I realize you don't do hard copy, but I still do hard copy, is I'm getting my copy of the New York Times, and there on page 1 is an article about a case, a Fourth Amendment case that seemed not terribly consequential to court watchers, called Herring, H-E-R-I-N-G, versus the United States. Herring versus United States involved the following fact situation. Well, it'll take too long to describe the facts. I can if you want to. But let's just say a bureaucratic snafu in the sheriff's office. Okay? Arrest warrant, supposedly outstanding from another county. Whoops. The arrest is made, and guess what? The person arrested was a convicted felon in possession of contraband, drugs, and a firearm. And even though this was good police work by an investigator in this southern county in Alabama, obviously this person was a not so nice person, Mr. Herring. I mean, he apparently a fairly dangerous guy. But it turned out that there was no valid arrest warrant outstanding in the county where the arrest was made. But when the check me on the facts, when the check was made with the next door county, they reported back, oh yes, we do have an outstanding arrest warrant, and so an intrepid investigator who may have had a little bit of malevolence in his heart with respect to this particular individual says, aha, and so the arrest is made. Within 10 to 15 minutes, according to the Supreme Court opinion, the majority opinion, a mistake was discovered. No, there was no outstanding arrest warrant. You see, that arrest warrant had been torn up some 6 months before, right? It was not only stale, it was just no, it doesn't exist. So it was an unconstitutional, although there was some interesting discussion in the majority, was this really unconstitutional, was it unreasonable? But it clearly was stipulated and was presented to the court. There was a violation of the Fourth Amendment, okay? And therefore, what remedy should follow? And the issue then became, should the Fourth Amendment exclusionary rule be applied in the context of, everyone said, wasn't intentional, No one's lying. This was an honest, bureaucratic mistake. So what happens under these circumstances? So the New York Times is describing this case, which actually was a couple of weeks old at the time, and I read it with interest. I actually was there for the oral argument, not because of it, but just by happy coincidence. So I saw the case being argued, and I thought, this is not a huge case, but it's not an unimportant case either. The New York Times suggested that the 5-4 opinion authored by, the majority opinion authored by Chief Justice Roberts, perhaps portended a great victory that had long been sought by lawyer John Roberts during his years as a lawyer at the Justice Department, but specifically as in the White House counsel's office, namely the abolition of the Fourth Amendment exclusionary rule. And reference was made to, one of the iconic Warren Court decisions, Mapp against Ohio in the early 1960s. I use it just as illustrative of here was an enormously important opinion from the Warren Court, Mapp versus Ohio. You're familiar with it. The Fourth Amendment exclusionary rule being extended to the states. It had theretofore not been extended to the states. And there was precedent on the books saying we're not going to extend it to the states, including most emphatically in a case called Wolf v. Colorado, which was 20-plus years old at the time that Mapp versus Ohio was argued. What is fascinating is when you drill back, as I have, into Mapp versus Ohio, and if you go back and read the opinions, you'll see, Mapp versus Ohio did overrule Wolf versus Colorado. That was 5-4 also. The Warren Court majority, in the face of a pretty strong dissent by Justice Harlan, joined by others, there was, what shall I say, pretty strong feelings. One of the feelings articulated by Justice Harlan in his very gentle personly way was the issue hasn't been briefed. This was presented to us as a First Amendment free speech case because Dolly Mapp possessed such material that raised alleged pornography and so forth. And so she was making a First Amendment case because clearly the First Amendment applied in corporation to the states. I have heard a counsel, and I've not gone back to the actual transcript, but someone who was clerking at the time, Dan Resnick, say, I was there in the courtroom clerking at the time, and I heard the following exchange. So we can go to the transcript. Justice Frankfurter, counsel, are you suggesting that we overrule Wolf against Colorado? Counsel, Your Honor, if it goes against my client, then yes, I want you to overrule it. And they did by a 5-4 margin. Justice Harlan was saying, wait, this wasn't even argued. It was barely mentioned at oral argument. It was not briefed. There's a procedural irregularity about this. Now, years later, I've been clerking at the court, and I've come into the orbit of Justice Tom Clark, the author of Mapp versus Ohio. He is a retired justice at this stage. A lovelier man never walked the planet. Just terrific. And I was charmed. Everyone loved Justice Clark. Then, after I left the clerkship, and then when I was serving in the Justice Department on tour of duty number 2, a very interesting conversation occurred with a then sitting justice on the Supreme Court of Israel who had been the chief prosecutor of Adolf Eichmann, a terrible war criminal. The one and only time that the death penalty, I think, has been imposed in Israel was against Nazi war criminal Adolf Eichmann. He was the chief prosecutor at this time he was serving on the Supreme Court. He said, you might be interested in this because you're serving in the Justice Department, you're arguing these cases, including Fourth Amendment cases, etc. I had a conversation with Justice Clark not long after Mapp versus Ohio came down. I was a prosecutor at that time, but I came into the United States, and he was kind enough to see me. And I said, we have not embraced the functional equivalent of the Fourth Amendment exclusionary rule here in Israel. And I was just very interested because obviously you overruled a case that had been on the books for quite some time, stare decisis, constitutional law less important, et cetera, but nonetheless I'd be interested. He said, here's what Justice Clark said. We knew we had to do something to clean up the police departments of this country. Now, that's the idea of progress. We have to use our power to clean up the police departments. Now, if you go back to Herring versus United States, you will see now this conversation going on about Mapp versus Ohio, with Justice Ginsburg lifting up a beautiful vision of the power of the Fourth Amendment and the need to protect individual rights, but also a very important value to Justice Ginsburg in dissent, joined by three of her colleagues, and that is judicial integrity, that the courts should not be handmaidens of lawlessness, my description, but rather courts should be using their power to ensure that the integrity of the courts is in fact fully protected. I dwell on the Fourth Amendment just to use it by way of illustration of the continuing meditation and reflection over these 30-some-odd years on the work of the Warren Court. Think about religion in the schools. Today was the National Prayer Breakfast. One of the things lifted up at the National Prayer Breakfast, I don't think President Obama agreed with this, is there really has been an unduly rigid approach toward religious activity in the public schools. Meditation on Engel versus Vitale, Abington School District versus Shem. Think of, even though it doesn't seem quite so current, Brown versus Board of Education, and then the remedies and the remedial stage of Brown versus Board of Education, and then the powerful statement by the Supreme Court of the United States in Cooper versus Aaron, speaking not per curiam, not by the court, but by the named individual justices, saying to the authorities in Little Rock, but really it wasn't Little Rock, it was the governor of Arkansas, stop standing in the door, stop standing in the way of federal power vindicating the constitutional rights of these school children to be able to attend desegregated schools. And then go forward to the use of federal remedial power. The Berger Court in Swan versus Charlotte Mecklenburg in the early 1970s just saying, chancellors sitting in equity, they are close to the facts. We're going to protect their ability. Milliken versus Bradley, when we were clerking, Milliken 1 and Milliken 2, no inter-district remedy in Detroit, but by golly, with respect to intra-district remedies, a very broad, sweeping power that the courts enjoy. And then go to the Rehnquist Court in Oklahoma City School Board versus Dowell. No, the era has to come to an end. In case after case, in issue after issue, in civil, but especially in these arenas that really is civil justice, but especially in these arenas that divide the people, the so-called social issues, even though the Warren Court didn't speak to abortion rights, but Roe v. Wade, looking back in sort of a Warren Court methodology of a very robust view of human liberty, and then the reflection and meditation on that. And so the good news is, you're just looking back at essentially 15 years of jurisprudence and continuing to reflect and meditate on that. From my own view, I think that I will close with a quotation from Akhil Amar. It's important to remember the life experiences of those, because they do count, of the justices who served, beginning, of course, most famously with the person who occupied the center seat for those 15 years, 16 years, Earl Warren. Himself, someone who suffered from crime. His father was murdered. And he was drawn into the law, came from humble roots, son of immigrants on both sides, Norwegian and Swedish. Lived in Bakersfield, California, not exactly the world's most, what shall I say, elegant spot. Right, John? And yet, drawn to the law, drawn to Berkeley, and then to what was until recently called Bolt Hall. But he was drawn to public service, and he wanted to serve, and he became a great prosecutor. Not only was he district attorney, renowned as district attorney, and he was a trial lawyer district attorney. He tried cases, not just making the executive decisions that are so important, but he tried cases. And he tried them very well. And he was courageous. He was a reformer. And then he was elected the Attorney General of California. And then he was elected governor, not once, not twice, but since California became a state in 1849, no one has been elected governor 3 times. In fact, we recall our governors in California. We don't reelect them, we recall them. 3 times. And in his 3rd race, he was not only the Republican nominee, he was a Republican throughout his career, he was the nominee of the Democratic Party. That's how renowned he was. And then, of course, he became, some of us may not remember this, but we know it from history, the vice presidential nominee in 1948 when it was thought politically that it was a shoo-in election for the Republicans. And, of course, Harry Truman gave him hell and won his own election as President of the United States. So that's the background of that. But think who else was with him, the Hugo Blacks and the William O. Douglas, and I close with Akil Amar. We now have the complete judicialization of the judiciary. We have no one on the court who has had these kinds of formative experiences in the political branches. Hugo Black, United States Senator, William O. Douglas, serving in the executive branch, part of the Brain Trust. And you see, it will be a very interesting question for President Obama when presumably during his 4 or more likely 8 years as President of the United States, and we wish the best to all of our justices, but John Paul Stevens is 88 years old. It suggests to us that if President Obama serves for 8 years with other justices in their 70s, he will have 1 or more appointments. Will he, in fact, do that, which President Clinton was tempted to do, which was go, Susan Wright, a very different route, to go to Mario Cuomo, someone very bright, very capable, extraordinarily articulate, who had graduated very high in his class at St. John's Law School, but who had really lived his life not so much in the law, but in politics and public policy and so forth. A very different kind of model. And George Stephanopoulos, of course, teaches us in his book, As I Saw It or something. But anyway, his book from his service under President Clinton was really what President Clinton really wanted. Someone to sort of be a new, not as Chief Justice, he didn't have that opportunity, a new kind of Earl Warren or a Hugo Black or a William O. Douglas. That was not to be, but then how did President Clinton go? Well, he went in favor of 2 extraordinarily capable, intelligent, and deeply respected, universally respected judges, Judge Ginsburg and Chief Judge Breyer. The judicialization of the judiciary. No person serving on the Supreme Court in recent years has ever been in the rough and tumble of public life. The closest was Sandra Day O'Connor, who was elected several terms 2 terms, as a state senator. That's it. And remember, we talked about Potter, of course, Thurgood Marshall, never elected, but still serving that great public life. And you're being privileged to clerk for the great Justice Marshall. It's a very different kind of court. So I leave you with this reflection after 39 years of court watching. Are we now in for a change? I will bet you, even though he was president of the Harvard Law Review, that President Obama is going to be very tempted by the President Clinton model, and if I may say so, the President Eisenhower model. Let's get someone in there who has really been in the rough and tumble of public life. 39 years of reflection, that's a pretty modest one. Thank you. That was much longer than I intended. That was 55 minutes. It was like Felix Frankfurter at conference. I apologize, and I look forward to your questions. Thank you for your attention, and thank you for the honor. Thank you. And knowing that I'm the last thing, they do have the wine out, so we can make this as short, Mr. President, as you would like. And I see no hands. They want to go to the bar. Oh, I'm in trouble. Professor. And you know more about this subject. Why did I go? Fools rush in.
It's a great speech, and
Thank you.
I'm a little bit surprised because it sounds like you are admiring of the judges that come out of a public policy making legislative background and admiring of the progress notion that you outlined, and I just would have thought.
Oh no, a pox on that entire methodology.
I would have thought.
But I'm giving honor to whom honor is due. Oh no, I don't think that the Article III branch should be an instrument of progress. I have a much more restrained and limited, the least dangerous branch. So if you want me to pontificate on my own vision, it would be a much more cabined view of the judicial power. But I recognize that what we are doing is really reflecting, I think, and meditating to this day on the work of the Warren Court.
That it's a continuing conversation, and I take it that you think it's a respectable view, but one that you may not personally agree with.
Right, and I think we also just have to recall context. I mean, to Tom Clark, who was the Attorney General of the United States, he knew stuff that, of course, now I don't know. So you can talk about the professionalism of law enforcement and so forth. I mean, how bad were the abuses? Obviously, I didn't talk about Miranda. Miranda, of course, has been vindicated. Dickerson versus United States by a 7-2 margin, including by one of Miranda's chief critics, Chief Justice Rehnquist, who obviously shifted his jurisprudential perspective, including talking about the culture, in his opinion, that the culture had, as it were, assimilated Miranda versus United States. So the great respect that Miranda held for conservatives on the court, even if they didn't agree with the methodology or the jurisprudence that gave us Miranda to begin with. So my point is really a more, as it were, neutral principle one, or just a neutral observation that we are continuing to meditate almost daily in the law and the work of the Warren Court, sometimes without realizing it. Yes, sir.
I wonder if you could draw any Warren Court lessons on the modern cases on the war on terror.
Warren Court lessons to Warren Terror. Well, if you believe in a very robust and muscular judicial power, that the judiciary is first among equals and must be heard and so forth, then I wouldn't be surprised for the Warren Court, especially in light of it being so sensitive, in light of the huge boneheaded mistakes in Korematsu, the Japanese internment cases. And I think the echoes of Robert Jackson's opinion, pre-Warren Court, in the steel seizure case, just before the Warren Court era, right? Wasn't that just before the Warren Court era? Yeah, of course, because Fred Vinson was in dissent. I think that would echo that, watch out for presidential power, including the Jacksonian observation that, and here I do take exception to the views of my very good friends in OLC in recent years. There's no emergency power, according to Jackson's concurrence, which has iconic status in constitutional law. You may think there should be an emergency executive power. And you say, well, what about Lincoln? Yeah, you're right. Didn't he suspend habeas corpus? Right. Didn't he do all these acts? You're right. He did all those acts. But he also looked to Congress to ratify what he did rather promptly, which may be one what should I say, important exception to the methodology of the immediate past administration. So I tend to think that the sort of extrapolating wildly and with very little foundation, that the Warren Court would have been very comfortable with saying, yes, Guantanamo was lost when it became clear that there's a Burger King on Guantanamo. I say that to make the broader point. This practical de facto sovereignty is so complete over Guantanamo that I wasn't surprised. Did I agree? We can argue whether the court was right. I don't think the Warren Court would have been too concerned with saying, Mr. President, you've gone too far. They probably would have enjoyed it. Yes.
Just sort of a quick question, not specifically about the law. And that is the idea of progress.
Yes.
Was what sort of caught my attention in what you were discussing. And progress, it seems to me, can be viewed as perhaps the most least eternal of concepts. We always have the word, but after every big war, after every depression, after every upheaval, after the French Revolution, progress meant something that it had not meant before. After the American Revolution, progress meant something.
Right. I mean, it's a very elastic concept. I couldn't agree with you more.
And that to the extent that judges try to stand outside history itself and reach for kind of enduring that would embody a sort of abstract.
Yeah, a natural justice, natural law approach. Yeah, and I think there you'll find a... I'm sorry, I keep interrupting. I apologize. No, I apologize. You're doing better than I am, so...
But no, my question was sort of to turn that back on the Warren Court and on its predecessors and its successors. And do judges have the gift of discerning, the light that is above the horizon, any more than the rest of us, or do they simply talk about progress the way most of us who have to answer questions rather than posing them?
I would add, that's a very rich set of reflections and question. My own limited lights lead me to this. I think the Warren Court was, quote, progressive, but in a deeply contextual way. It's very sensitive to context, including extra record context, because Earl Warren knew that police departments weren't always behaving so nicely, because he had been there, done that, in a way that you don't see, of course, in the academy. So I think they were very deeply contextual, as opposed to more abstractly philosophical. Indeed, Herbert Wechsler's famous critique, Henry Hart's famous critique of the Warren Court was, you people need to be good lawyers and judges. You're just kind of responding to the exigencies, the perceived exigencies of the day in a more policy-making way, as opposed to carefully, and I mean no disrespect to those who continue to admire the Warren Court, but the Warren Court was very severely criticized by the leading lights of the academy during the time. I mean, Wechsler and Hart, I mean, we still talk about Hart and Wechsler. To have those two folks dumping on the court's fundamental methodology as being, uncraftsmanlike and so forth. I mean, Henry Hart's, the time, forgetting the exact name, the time chart of the justices, it was a foreword to the Harvard Law Review's annual Supreme Court. I mean, he really dumped hard on this period. I mean, it's scathing. And then more elegantly, of course, Herbert Wechsler's toward neutral principles. They were all struggling to, even if they found the results congenial, for greater craftsmanship in the law. So I don't think this was a philosophical court at all, as illustrated by the anecdote of Tom Clark, Justice Clark, to this leading Israeli prosecutor. We had to do something to clean up the police departments. And that's something I just think none of the 9 justices these days, we may have disagreement, that's not our business. Even if we have the soaring vision of the Fourth Amendment, and Justice Ruth Ginsburg set forth a very beautiful vision of the Fourth Amendment and what the exclusionary rule is designed to do, I don't agree with it, because I'm a Cardozo guy. Why should the criminal go free unless the constable blunders? And so I'm a Felix Frankfurter guy. Namely, you reserve it, and I think that's what the court was saying through Chief Justice Roberts, for really bad behavior, and we know it when we see it. John.
I think your thesis is very interesting. I'm not sure, thinking back on it, that a life in the public square as opposed to a life in the courthouse necessarily results in what you labeled progressive jurisprudence. I think back to Charles Evans Hughes, William Howard Taft, even Justice McReynolds, all of whom I think had very active lives in politics before going to court.
Quite right.
And indeed, Justice Black, who came from what was thought to be an extremely conservative political tradition, I think.
Except he was a New Dealer. He had the Ku Klux Klan, and he had the not very pretty side.
It seems to me that in part, having actually one of the few people who was actually practicing law when the Warren Court was around, that to some extent that court was responding to the times. This was the times of the 60s. This was the late 60s. It was the time of Eisenhower was our parents' president. He wasn't our president. And I think there was a lot happening. You mentioned Little Rock. You mentioned what's going on in the culture. I think Judge, you know better than I, having been a judge, that judges, try as they might, separate themselves from the times they're in, have a very difficult time doing that.
Well, it's a struggle. There's no question. I'm sorry, I interrupted.
Maybe the life of the public square question should be more responsive to the concerns of the times, but I'm not sure that's true. If I look back on Nick Reynolds and Charles Evans Hughes and William Howard,
Yeah.
I don't think we could say that.
I couldn't agree more. I don't mean to suggest that life in the public square leads one to a particular philosophical view. If we look at the career, the life and career of Earl Warren, he was the great reformer. Now if you look at a law and economics person who happens to be elected to, has anyone been elected to the United States Senate who's a law and economics person who's economically literate? I don't know. They probably are there. Oh, true. But he's no longer sitting. Yeah. He was making money on Wall Street, which they don't do anymore. But no, I do accept the point. I embrace everything that you said and view it as a useful refinement of my much more crude theory. Warren.
No question.
I thought, where's the wine? Okay. David, I turn it back to you. Thank you for your attention. Thank you for the honor.
Starr, here is our Lifetime Service Award, a little trinket. Thank you very much for coming.
More than a trinket.
And we're thrilled to have you. Invite everyone to join us for reception immediately behind us.
We are dismissed. Make sure.
We actually have a box.
Oh, great.
So I'll pack this up for you.
Okay, that's great.
Figure out.
Hey, Judge.
Wow.